All right, welcome back to the video lecture series. This video here is going to talk a little bit more about the U.S. Constitution and specifically the power of the federal government as authorized or dictated in the U.S. Constitution. And so prior to the lecture, I just kind of wanted to start by asking a question, which is the one posed here on the screen. And again, I'm just using the outlines that I've posted, so you can watch the lecture and use the outlines to study and get ready for the exams in the future. So one question I want to pose. Prior to the ratification of the U.S. Constitution, what was the role of the federal government or central government? So prior to the ratification of the U.S. Constitution. So I'm pausing for a minute so you can think about it. Maybe you all are answering. And you could kind of think that think about the time frame of this. The Constitution was ratified 1788. I'll say this. On June 21st, 1788, New Hampshire became the 9th of the 13 states to ratify it. So if you really want to look back on it, it's a little confusing because it was ratified by the states at different times. But when they drafted the U.S. Constitution, 38 of the 41 delegates present at this constitutional convention said that as long as 9 of the 13 states ratified it, it would be controlling law. So it took a while. It was initially defined and agreed to at the convention in 1787, and then 9 of the 13 states ratified it June 21st, 1788. So prior to that, I think if we just kind of conceptually think about what was going on prior to this ratification of the Constitution, can you think of anything that happened prior to this that would have major significance? Well, we fought the American Revolutionary War. So the war was from 1775 to 1783. So, and if we think about kind of the reasons why we fought the American Revolution, we often think about the Boston Tea Party and taxation without representation, tyrannical governments, of writs of habeas corpus where they could, and other things where they could hold you and not allow and have barge into your homes without any kind of warrants. So we have all these conceptual ideas that we've heard about as to why we were fighting this tyrannical government in the American Revolutionary War. So when you have that as a backdrop to this constitutional convention, can you imagine that they were at the time wanting to have, answering the question that I posed, an unlimited powerful federal government? Do you think that's what they were thinking at the time that they had this constitutional convention, which was in 1787? Now, initially, what controlled from the middle part of the American Revolutionary War until 1787, when they had this constitutional convention, was something called the Articles of Confederation, which defined the central government's very limited role and really established this kind of confederation of independent states. At that time, the central government could only handle matters of common concern, which were expressly delegated to it by member states. So they really tried to say, no, you're a limited government. We don't want an all-powerful government. And you can imagine after fighting one and freeing ourselves from this all-powerful government, that they didn't want to just reinstitute one. And so they really struggled with how much power to give this federal government. And many of the delegate states didn't want a federal government at all. So they came up with this concept of the Articles of Confederation, and it further said that sovereign power to govern rested essentially with the states. The Articles of Confederation clearly reflected this central tenet of the American Revolution, which I've already said, that the national government or federal government should not have unlimited power. Serious problems existed during this time frame. Laws would pass by various states would hamper commerce and foreign trade and the free movement of goods across state lines. There was heavy taxes on imports, and sometimes in my lectures I'll describe it as children just fighting. And so what they realized is that they kind of had to rewrite these Articles of Confederation because they weren't really working. And so they all met to do this in 1787, and what became of that Constitutional Convention was actually the writing of the Constitution, and as I said previously, 38 of 41 delegates present signing that Constitution, and then a few years later, 9 of the 13 states ratifying it in 1788. So when we look at this and we say, okay, so they didn't really want to put a lot of power in the federal government. And so when they were writing the Constitution, that was kind of a main theme. And if you kind of look at some of the stuff online, or if you've done any kind of history of this, but you've heard the term the Federalist Papers. And this is some papers that were written by Hamilton and James Madison, and were really put forth to kind of tell the public. There was 85 essays, and they really defended this new proposal of the government. And so they would publish these, and people could read them and kind of figure out what was behind this concept known as the Constitution, and this kind of defining document that was going to control the United States of America. So when they went into this Constitutional Convention and drafted the first Constitution, can you imagine again what they were thinking? What was the system they were drafting? One, and what power do you think they gave to the federal government after understanding this Articles of Confederation discussion, post American Revolutionary War, but still with the backdrop of the troubles that existed between the states at the time, the fragile nature of the states, because we were afraid that perhaps we wouldn't even survive because there was such animosity and friction between the states. And so we knew we had to come together as a United States of America, and we needed a controlling document. But as you can imagine, there was a lot of discussion about the power that they would give the federal government. So, as I said, with that backdrop, and I pose this question in class when we have more of a dialogue between students and myself, as opposed to me just kind of lecturing at you in a video. But I pose this question: what do you, if I were to ask you, what do you think the power of the federal government is currently today, as it sits today? And then sometimes I'll pose the question: how do you think it's changed, or what do you think how is it written in the U.S. Constitution versus how it is today? A lot of times what I hear from students is that the federal government has unlimited power. They believe that they're a powerful federal government, that they have, sometimes I'll hear this supremacy statement about supremacy clause and being able to write laws and should have the supreme law of the land and that kind of thing. I'll hear different statements coming from students. And so think about it for a second, and then let's kind of come back and see where we are on it. So actually, what is the powers of the federal government that are contained in the Constitution? And then we'll come back and we'll kind of look at how we think they've changed over time and how we feel the power exists in today's environment. And so in the Constitution, Article 1 sets forth the powers of Congress. And we have what we call a federalist form of government. And it establishes these 3 branches of government, and it also establishes the power of the federal government versus the power of the state government. So these 3 branches of government: legislative, executive, and judicial. The form of government established also the power between the state and the federal government. And so the powers of the federal government, as dictated in the Constitution, are what we call limited or enumerated powers, meaning they're spelled out, they're written down, they're contained in the Constitution. So when we look at those, we can identify what those powers are. So just kind of in summary, the powers of the federal government are what we call express powers of the federal government. In other words, enumerated powers. As I said, are specific powers explicitly listed in the Constitution. We can primarily find these in Article 1, Section 8, which include if you look at Article 1, and I can show you a link to where we can find these in a second, but this is what they include. So Section 8, coin money, declare war, raise an army and navy, collect taxes, establish a post office, and the last one, or one that's contained in Article 1, Section 8 of the U.S. Constitution, is regulate interstate commerce. And we're going to come back to that, which is commonly referred to as the Commerce Clause, Article 1, Section 8 of the U.S. Constitution, to regulate interstate commerce. And so we'll come back to that in a second. So here we are. So we have this limited federal government, by definition, by the Constitution, limited only because they say they are enumerated powers, or spelled out powers in the U.S. Constitution. I just read you the powers. More specifically, the 10th Amendment to the U.S. Constitution set forth parameters that said all those powers that are not given, expressly designated to the federal government, are left to the states. This is the 10th Amendment to the U.S. Constitution, which here's the language of the 10th Amendment right here. This is powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. So basically, the federal government, had explicit stated powers, and all the other powers were reserved or left to the states. States have the general police power, which allows them to enact legislations for health, safety, and welfare, whereas the federal government does not have a specific police power. So discussing further this concept of the federal government's power. So specifically, to regulate business activity, to regulate citizens within a state, to regulate states' action, those persons within a state, businesses in a state. We need to look again at Article 1, Section 8 of the U.S. Constitution. So a lot of students will look first time at the Constitution and think, well, what is the power of the federal government? As I said previously, a lot of students say it's unlimited. They can create any law they want and apply it to individuals and in the states. We would call that unlimited federal government power. No limit whatsoever. But what we've learned here is that the Constitution says something specifically different. It says that there is explicit enumerated powers to the federal government and everything else is left to the states. And again, I want to pause here and have you think about this. Does it feel that way today? And as we go forward and answer this question and look at the areas of law, specifically the Constitution that allows the federal government to regulate, whether we feel like that power is expanded too greatly, whether it's perfect the way it is, and I'll kind of leave that open for discussion. But at least in your mind, start thinking about that right now as we go forward, and I'll give you some examples of federal government regulatory power here in a second, as the book does as well. But if we look to the Constitution of the United States, the U.S. Constitution, Section 8, says this, the language of the Commerce Clause. Remember how I said briefly that one of the powers that the federal government was given in the U.S. Constitution and ratified was this Commerce Clause, the power to regulate commerce. So remember, historically at the time, there was kind of infighting among the states. There was taxation, a heavy taxation on imports, and other things that were kind of creating this fiction and inability of the states to work together and become united. And so what the Constitution said and what was agreed to at the time of writing and then ratifying the Constitution was this language that said this: Congress shall have the power to regulate commerce with foreign nations, among the several states, and with Indian tribes. So commerce, meaning business, right? The power to regulate business. So Congress, again, reading it again, shall have the power to regulate business with foreign nations and among the several states, and with Indian tribes. So the most influential, the most important language of Article 1, Section 8 is power to regulate commerce among the several states. So this broad clause forms the basis for most of the federal government's power to regulate interstate commerce and commerce within the state. Intrastate and interstate commerce. This says interstate, but I would say intrastate as well. This clause, as I said, referred to as the Commerce Clause, has had a greater impact on business than any other provision in the Constitution. So as we consider this clause and the application of the Commerce Clause and the Supreme Court's analysis of this language, because remember when we talked about primary sources of law in the first lecture, we said, all right, we have to find the law. We have to, when we're studying cases, we have the law and then we apply it to facts, a disputed argument, right? In this case, it would be a dispute between an individual and the state or the state itself against the federal government for some legislative activity, a law that big C Congress has made, and then applied to the states, right? And so then the state or a person within the state would challenge that and say, hey, you've gone beyond your powers delegated to you in the U.S. Constitution, so it's an unconstitutional act by the federal government. That would be the argument by the state or an individual within the state if they're being sued under one of these federal statutes. And sometimes we refer to this concept as a conflict of laws, or I will, as a conflict of laws between federal and state governments. In other words, at the state level, there could be a law that says one thing, and at the federal level, there could be a law that says something else. And so, can you think of anything currently that would fall within this parameter? Good. Yes, I can think of the same thing. So we're talking about this legalization of marijuana. So what does that look like? So in California, the state of California has instituted a statutory law that says that, I don't know the exact law to be honest with you, but what it says certain things about marijuana are legal. They've made marijuana legal for personal consumption. A lot of my students know much more about the law than I do, but let's just say this, that it legalized marijuana, at least private, personal use of marijuana. Now, does that conflict with the current federal law? Yes, under federal law, marijuana is still defined as a controlled substance under the federal law. In other words, it's illegal. So that forms the basis of this conflict between the state's powers to do something, legalize marijuana, and the federal government's power to control through their enumerated powers to create law and apply it to the states and individuals within the state. Right? So we have a conflict of laws. At the federal level, marijuana is illegal under the Controlled Substances Act. At the state level, they've authorized it for personal use. So we have a conflict. So what could happen is that dispensaries or individuals or anything could be possibly prosecuted by the federal government in violation of the Controlled Substances Act for doing something that's legal in the state in which they live, California. So how do we resolve this? How do we resolve this conflict of law where federal law and state law conflict? And some might say, oh, okay, it's an easy answer. Supremacy Clause. The Supremacy Clause says that the federal government is the supreme law of the land, so their law wins. Well, wait, we can't go there yet. We have to go one place first. Why? Because the Constitution says that the federal government only has the right to do their enumerated powers, right? Those that are written down and given to them specifically. So where do we go? We go to the Commerce Clause. The Commerce Clause says Congress shall have the power to regulate commerce among the several states. So you can imagine, and we'll throw some case law in here as well, because there was initial cases said, oh, well, if I'm not transporting something across state lines, interstate, not intrastate, if something was wholly intrastate, then the federal government didn't have the power to regulate, right? Then I was okay. The state law would win. But cases have changed that, and one that's in your textbook, and I have written down here one too as well, Gibbons versus Ogden, a Supreme Court case, but one I like better to exemplify the analysis of the Supreme Court is the Heart of Atlanta Motel case. And the Heart of Atlanta Motel case is kind of an interesting case where there was a hotel owner, owned a hotel in the heart of Atlanta, and he refused to rent rooms to African Americans. So that, and state law didn't forbid that act in Atlanta at the time. However, the Civil Rights Act, which is federal law, said that that was unlawful. His behavior was unlawful. So again, just like the marijuana law, we had a conflict of laws. The Civil Rights Act on one hand at the federal level, and at the state level, we had this no state law invalidating the actions of the owner of that Heart of Atlanta Motel establishment. So the Heart of Atlanta Motel case said perhaps the owner of the Heart of Atlanta Motel case might have said exactly what a dispensary might say in California, which is what? Hey, federal government, you don't have the power to regulate me. The Commerce Clause says you only have the power to regulate commerce among the several states. Among the several states. This is wholly intrastate. This is not affecting interstate commerce across state lines. Well, what do you think? Is that a good argument or a bad argument? It's a bad argument. What the Supreme Court said is Congress may regulate those activities having a substantial effect on interstate commerce. If the activity is commercial in nature, commerce, then it doesn't seem to matter whether the particular instance of the activity directly affects interstate commerce, as long as the instance they can show a general, if they can show an instance is part of a general class of activities that collectively would affect interstate commerce substantially. In the aggregate, if a bunch of small people did it, small actors did it. So there's this concept out of the case says, listen, I guess good effort on your argument that, okay, you're reading the language of the Commerce Clause specifically, and it says interstate commerce, not intrastate. So they argued, hey, my acts are wholly within the state, intrastate only. But the Supreme Court said no, because if there was a bunch of actors, even though you're a small actor only in the state of Atlanta, what if a bunch of hotel owners did that in the state? That those small acts, individual acts, collectively would have a substantial effect or impact on interstate commerce. And because of that, the Supreme Court said that the Commerce Clause applies to those activities as well. And so when we kind of expand out and say, okay, so then what are the four broad categories and the power that's expressed through judicial decisions, case law, that has analyzed the Commerce Clause? It is the following. Congress can regulate the instrumentalities of interstate commerce. That refers to people, machines, and other things used in carrying out commerce. They can regulate articles that actually move across interstate or state lines. And they can regulate the channels of interstate commerce, which is highways, waterways, air traffic. And they can also regulate those things that, even if they're wholly intrastate or small, de minimis in their acts, would in the aggregate substantially affect interstate commerce. So if you're watching this video, good for you. Thank you. And this could help you answer the CT or critical thinking exercise essay that I have put out there for you guys to do this week. And so within your answer, you might want to talk about this concept of Article 1, Section 8, and what kind of powers the federal government currently has to regulate state activity and actors within the state. The last thing is this supremacy clause, and a lot of students, as I said, will jump to the supremacy clause first. And remember that is a good answer, right? That the supremacy clause does do that. It is the supreme law of the land. The only thing that you have to think about and remember is that in order for the federal government, big C Congress, to enact legislation, they have to have the power to do so. And so we told you what the power of the federal government was, or I told you what the power of the federal government was, right? And it's enumerated, and it is, again, right, to coin money, declare war, raise an army and navy, collect taxes, establish a post office, and these are the broad categories, and regulate interstate commerce. And that really has become the real power for the federal government, is this Article 1, Section 8. Believe it or not, this is the article of the U.S. Constitution that is used by the federal government to create legislation at the federal level and apply it to the states and citizens within the state, is this Commerce Clause power. So do they have the power to regulate? We need to analyze this Commerce Clause argument. Now, what's interesting is if you take a look at the historical cases on the Commerce Clause, there has not been very many federal statutes overturned for an invalid use or for unconstitutional use of the Commerce Clause, is what I'm trying to say, right? That they have not held Congress's legislative activity unconstitutional based on the Commerce Clause. And only once did they do that, and this was a Gun-Free School Zone Act, which was a federal law that said it was illegal to have a firearm and a gun within a school zone. And the Supreme Court said no, that invalidated, that was unconstitutional, that was went outside the parameters of the Commerce Clause, and that's one of the only statutes that's been invalidated by the Supreme Court using the Commerce Clause argument. And whether, and this, to kind of end this lecture, because I'm going on almost 30 minutes and these are supposed to be 15-minute lectures, so sorry about that. But talking about this concept of the Commerce Clause is kind of, to end this lecture, is to ask again, so if we're trying to figure out how we feel about the power of the federal government currently, is it unlimited, all powerful? Well, it feels that way, I think. A lot of students would say that. I think a lot of people would say that. Is that how it was initially designed or written in the U.S. Constitution? Well, I think that's up for debate. I think the Supreme Court has said, well, the broad language of the Commerce Clause allows the federal government to enact legislation as it relates to commerce among the states. And when they define among as both interstate and intrastate activity that in the aggregate would have a substantial impact or effect on interstate commerce, they have really expanded this language. That is not to say they're wrong. I'm just saying that this has really given the federal government power to regulate state activity. And as I said, if the federal government can find this connection to commerce, then there has not been a Supreme Court invalidation of a federal statute or law when the federal government argues that they have the power under the Commerce Clause. The only one so far is the Gun-Free School Zone Act. So this language has really created a significant power for the federal government as it relates to enacting legislation and applying it to the states. This is so this discussion, I think, is an important one, and this is why I have the CT on this as well. But this is an important discussion that's going to go beyond this class, and you might be hearing this discussion as we go forward for the next 10, 20, 30, 40, 50 years, as we kind of wrestle with this idea of states' rights and the federal government's power to regulate states and individuals within the state. There's a lot of issues in the states. There's a lot of issues when states have conflicting laws, perhaps, right? And then the federal government might want to come in and say, hey, we're going to take over and we're going to occupy this field and we're going to create legislation and apply it to the states. So, keep your, ears open, and if you hear talk about federal government's powers and states' rights powers, then you know that typically you might know more than the people that are actually talking about it, that it's Congress's power to regulate commerce comes from this Article 1, Section 8 of the U.S. Constitution. I appreciate you all listening to this video, and I will, obviously there's more videos for you to look at, and if you want to look at the outline online, I've posted it online, and if you have any questions, feel free to email me and we can answer them, or you can set up a private Zoom meeting with me if you'd like to do that as well. So thanks again for watching.